I want to talk briefly today about the Supreme Court birthright citizenship case that came out last week. More specifically, I want to address quotations from the legislative history of the 14th Amendment that conservatives keep insisting proves that it never intended to grant birthright citizenship to the children of non-citizens. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. Now, this quotation they keep referring to comes from Senator Jacob Howard of Michigan, the principal Senate sponsor of the 14th Amendment. And here's exactly what he said. The amendment will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. Now, before we parse that quote, there's a much more fundamental point here. The starting point for any legal analysis is the text itself. And the text of the 14th Amendment really could not be clearer. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Now, again, under the ordinary rules of legal interpretation, if the text is clear, the analysis ends there. Courts don't begin by rummaging through legislative history looking for snippets of congressional debate. They begin and usually end with the words that were actually enacted. And again, the text of the 14th Amendment is perfectly clear. If you are born in the United States and you are subject to the jurisdiction of the United States, which is to say, you are required to obey American law and American courts have authority over you, then you are a citizen. And again, that is perfectly clear. It doesn't require any interpretation for the mere fact that the opposite proposition would be ridiculous. If someone were truly not subject to the jurisdiction of the United States, then our courts would have no authority over that person. We couldn't prosecute them for violating our criminal laws. We couldn't compel them to appear in court. We couldn't tax them. And we couldn't deport them through our immigration courts, because deportation itself is an exercise of the jurisdiction of the United States over a person physically present within the United States. Now, historically, there's only ever been one class of individuals that has been genuinely not subject to our ordinary legal authority: accredited foreign diplomats and their families who enjoy diplomatic immunity. So again, before we even parse Senator Howard's comments, the constitutional text itself provides a straightforward answer to any of these debates. But just for the sake of argument, let's pretend that Senator Howard's comments are somehow relevant. Again, taking Senator Howard's comments at face value, these reactionary arguments still fail. Why? Because lawyers don't just make up rules for reading legal texts. We have established rules of construction that tell us how to interpret statutes, contracts, regulations, and constitutional provisions. These rules exist precisely to prevent people from twisting language to reach a politically convenient result. One of the most basic rules of legal interpretation is this: words matter, grammar matters, and courts are supposed to read sentences the way an ordinary English speaker would. And in keeping with that, when lawmakers write a list or they include a descriptive phrase after a series of words, courts don't simply guess what the author meant. They apply established canons of statutory construction. One of those canons provides that when a qualifying phrase follows a series, it ordinarily applies to the entire series, not merely to the last item. Another rule of statutory construction holds that courts should avoid reading legal text in a way that renders some of the words meaningless or redundant. The assumption is that whoever wrote the law chose their words carefully. Every word is presumed to have been included for a reason. Now, let's read Senator Howard's sentence again as you would read any other sentence in English. The 14th Amendment will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. The phrase, who belong to the families of ambassadors or foreign ministers, naturally describes the entire preceding series. Foreigners, aliens. Foreigners and aliens are near synonyms, and used together, they identify a single category of people: foreigners or aliens who belong to diplomatic families. That is the only way to read that sentence so as to give every word meaning. And by that reading, it explains why diplomatic families are singled out. That is the only way to make sense with the concluding statement that the citizenship clause will include every other class of persons. This isn't a political argument, it's a grammatical one. It's about applying ordinary English and established rules of statutory construction instead of rewriting a sentence to reach a preferred ideological outcome. And here's the part that I find especially amusing. The rules of statutory construction I've discussed in this video are not mine. I've taken these rules directly from a book called Reading Law, The Interpretation of Legal Texts by Justice Antonin Scalia and Brian Garner. Yes, that Antonin Scalia, the conservative icon, the justice who spent his career insisting that judges should interpret legal texts according to their ordinary public meaning and established canons of construction. So, the lesson here for these reactionary political commentators is that if you're going to call yourself a textualist, follow the rules of textualism. Read the constitutional text as it was written. Read Senator Howard's sentence as it was written. You don't get to pick and choose when the rules of statutory interpretation apply. The sine qua non of intellectual integrity is to apply the same standards in each situation, even if it comes to a conclusion that you don't like.